As I'm sure you all know, throughout a student's career, they might face some issues in terms of behavior or discipline. And that's especially true, I think, for special needs students. Parents of students with special needs are often confronted with school disciplinary issues. It's extremely important that parents of students with special needs understand the rights associated with school discipline.
School discipline in New York City uses what's called a progressive discipline model. That's their term. According to them, in their own handbook, the goal of discipline is, is to not seek punishment, but rather to have its dual goal of concurrent accountability and behavioral change. That is what they say. That is not the reality. It is punishment. And when you go to a hearing, you have to remind them that that is the goal and that they are there not just to punish kids they think are bad kids. And progressive discipline basically operates in two ways. It's about the severity of the offense. A lesser offense, the punishment gets progressively more serious for a more serious offense. And based on the student's disciplinary history, a student getting in trouble for the 5th time is likely to face a greater consequence for the same action as a student who gets in trouble for the 1st time. Now, the school lists, and this is a book that, for anyone who does this, it's a citywide behavioral expectations. This comes out every single year. You can find these in any of the school suspension offices. There's at least one in every borough. Brooklyn has 2. And they put them out every year, and they're important because they sort of update the law. What basically is their law, the law of essentially the penal code of schools, which is the student conduct code. But what they list when they're determining disciplinary response in the schools, and they need to be reminded of this, is a variety of factors. One being the student's age and maturity, the student's disciplinary record, the nature, severity, and scope of the behavior, the circumstances, context in which the conduct occurred, the frequency and duration of the behavior, the number of persons involved in the behavior, and the social, emotional status needs of all persons involved in the behavior, and the student's IEP and BIP, which is behavioral intervention plan. That all needs to be considered. Now, there is a large range of disciplinary options, and each of these carries different, essentially, minimums and maximums. This is sort of like a criminal case in that, there's maximum punishment, minimum punishment, and these offenses are grouped into 5 different categories. And some of these categories are narrower than others. And within each category, each category will have a variety of punishments that are permissible, but some offenses within that category will have a narrower number of punishments applicable to them. The lowest being Level 1, which is considered uncooperative behavior or non-compliant behavior, things like cutting class, inappropriate clothing, being disruptive in class. The range here is a meeting with students, parental conferences, in-school discipline like no out lunch or exclusion from extracurricular activities, which I think is completely counterproductive, removal from class. Level 2 being disorderly behavior, things like smoking, gambling, using profanity. It's the same level of discipline, it's the same punishments as Level 1. So nothing major, no suspensions, no expulsion. But once we get into Level 3, it kicks up a bunch. That's disruptive behavior. Ethnic slurs, minor physical altercations, not fights, shoving past someone, gang-related behavior, but not violent, gang signs, gang clothing, vandalism, and scholastic dishonesty. This is where cheating comes in. The bottom range is the same as Level 1, but for some of the offenses, a principal suspension is applicable, and I'll get into what a principal suspension is in a little bit. I'll tell you right now, it's a suspension for 5 days or less. And then it allows for some 6 to 10 day suspensions only for egregious academic dishonesty or vandalism with substantial damage. Vandalism with substantial damage, you can get up to a 90-day suspension. Now, level 4 and 5 is what I deal with mostly in my practice. Those are where you're really talking about serious suspensions, serious offenses. Level 4 being the largest of all of the 5 categories, aggressive or injurious or harmful behavior. This is sexual conduct, consensual. Sexual harassment, fighting, bullying, drug possession, stealing, and then minor weapons.
Cyberbullying.
Yeah, that's within bullying. At least 6 to 10 days is all have at least a 6 to 10 day suspension. Most 60 to 90 days, and a few for 1 year. Now they have lower punishments as well, but they all carry a potential of all of those superintendent suspensions. Superintendent suspension being a suspension more than six days or more. Level 5 are the really serious stuff, the seriously dangerous or violent behavior. This is where someone can get expelled. But they cannot be expelled unless they had turned 17 prior to the beginning of the school year. So if their 17th birthday was on the second day of the school year, they cannot be expelled. This is where someone has attempted to set fire to something in the school, essentially a robbery, stealing with force, force on school personnel, excessive force on a student, so fighting with serious injury, gang-related violent behavior, sexual aggression or compulsion, selling drugs, and then most weapons. Now, what I really am going to focus on here is the suspension, because suspension is really when we talk about what the rights are when they kick in. There's 2 types of suspensions, as I said before. The principal's is a 1 to 5 day. That when there's going to be a principal suspension, there's basically an informal meeting. It's the principal, and you can be represented by counsel. It's not as necessary here as a superintendent suspension. It's most time people are not represented by counsel in a principal suspension. It's a meeting, but you have rights here. The principal must tell you what the accusations are. They must explain the evidence of the accusations. They can't just say your kid's suspended for smoking pot. They have to tell you who told, how they know, when they did it. Give the kid a chance to tell their side of the story. The conference must be within 5 days of a letter explaining the suspension. Typically, in this situation, the student is not out of school until the meeting, and then they'll be out of school afterwards. And at the meeting, you're entitled to challenge the suspension or brainstorm a way to address the child's behavior in the future. So it's supposed to be a collaborative meeting where, okay, the student's going to be suspended for 2 days, but what are we going to do going forward? Now, the biggest thing is superintendent suspension. That's more than 5 days. And here you get into basically a mini trial, a real court process. What happens here is you get a notice of suspension. And in a notice of suspension, there's a bunch of things that must be there. One is the alternative placement site. Your student is being removed from school pending this hearing for violent or threatening behavior or something along those lines. During that time, the student will be going to school X. They're given because they can't be out of school for 10, 20, 30 days. They're given immediately an alternative placement site. This is a school, but the kind of education here is not the kind of education you want permanently for your kid. The hearing date is always 5 days out from the date of the suspension. So you have to move fast. And people get tripped up here because it's such a quick calendar. This leads to mistakes. People go in unrepresented. Very hard here. It's just like we were saying before in the due process. It is a formal hearing presided over by essentially an administrative law judge. It's a trial. You have to be able to cross-examine the other side's witnesses. You don't know to get discovery. It's so fast. You have more discovery in something like this than you do in a criminal case. You actually get a package called the suspension packet from the school. And people make the mistake, and a lot of parents say, oh, my kid did it, I'm just going to plead no contest. That, much of the time, is a tragic mistake. The notice has the charge. It won't say, because all the infractions are sort of codified with a number and a letter. It will not say that. It'll say, your student did X, and then you have to sort of look at that and go through this document and find which of the infractions it lines up to so you know what level you're saying. They will not tell you what level offense it is. You have to figure it out yourself, or if you have an attorney, the attorney will figure it out. There's a witness list, which is non-binding. It's all the people they may call, but they also may call someone else. And if your student has a disability, there'll also be an MDR date. That's a manifestation determination review. I'll get into that in a minute. And you won't know if you're actually going to have that until after your hearing, even if you lose. Because in order to get an MDR, your student must either be facing at least a suspension for over 10 days, for 10 days at that time, and get that, or a total of 10 days of suspension over the course of the year. So several principal suspension can lead to an MDR. It's a total amount in a given school year. You can adjourn. Often I will adjourn a few days. There's a balance it's really a balance of whether or not you want to adjourn. If you think your child is only going to be suspended for 6 or 7 days and you ask for 2 weeks to adjourn to prepare, now you're keeping your student out of their school longer than is necessary. But if they're asking for a year, 90 days, even 30 days, you often want to adjourn to make sure you can get all the documents that you need for mitigation, make sure you get the full suspension packet, have an opportunity to review. This is a balancing act. What you need to do, and this is what every parent needs to do, this is very important, is get the suspension packet. Often they will not give it to the lawyer. Sometimes they will, usually they will not. The suspension packet should have, and sometimes they give it incomplete. It should have your child's attendance. It should have your child's grades. It should have your child's disciplinary history. It should have witness statements. Sometimes people just give you the first 3. Witness statements, every witness who may be called in these school processes, everyone writes. They ask everyone to sit down and write. They'll ask your child to sit down and incriminate himself or herself. And you get every witness statement and any documentary evidence they're going to put into evidence at the hearing. You're entitled to that. And the parent needs to know to ask for it. Before the hearing, you should know if there's any witnesses you want to call from the school or outside. You get to subpoena the witness. To subpoena a witness, all you have to do is call the Office of School Suspension and say, I want to subpoena this witness, and they'll do it. It takes a phone call. Mitigation letters. Because it is not like a situation like a criminal trial where you go to trial, and if you lose, later there's sentence. You litigate sentence, essentially, at the same time as you litigate guilt or innocence without knowing what the result on guilt or innocence is going to be. And so you need to be prepared for letters showing that your kid is a good kid, does things outside of school that are good, is involved in extracurriculars, has certain psychological issues that may come into play. Letters are important here. And if you can, what Lori was saying about having relationships with the school, this plays in. Find out what the school is recommending. The school checks a box as to how much time they're recommending. And if you know that going in, that could help your argument and say, well, I know the school's on my side. Maybe I do want to I do want to do no contest because the school's saying my kid can go back right away and it's quicker. But you sort of want to feel them out for that so you know what you're dealing with. That will not be in the notice. You have to ask. No, why don't I like no contest, please? Quickly, no contest, please. You lose. And not only do you lose, most of the time you will lose these hearings. Your student will be found to have violated the code. But you don't get to, if you do it ahead of time, you don't get to discuss what's going to happen. You don't get to discuss punishment. And if you decide the day of, it's better to go the day of, and the day of say, now we're going to plead no contest, because then you still get to have the dispositional phase of the hearing. And you get to have that, and you get to put that on the record and have that conversation. So you don't want to do that ahead of time. But if you do, and you realize afterwards, holy moly, this is a lot more time than I expected. And I found the people who plead no contest tend to get more time than those who show up and lose. Everyone's afraid that they're going to hold. Oh no, they're going to hold it against my kid that we went, and they will not. They will hold it against you for not going. So you want to go. This is in my experience. And if you don't, you can always reopen it later. But they're often not willing to they'll reevaluate whether or not your child is essentially guilty, but they may not be willing to upset the punishment they've already declared in the letter they'll send you if you plead no contest. The hearing process itself. It's essentially, you go there, it's like you sit around a table, the administrative law judge is a representative of what's called the chief executive officer. They have a little tape recorder, there's not an actual reporter there, and you sit on one side with the attorney, if you have an attorney, the child and the parent on one side, all witnesses must be out in the hallway, and then your adversary is never a lawyer. It's 99% of the time the dean, who is the disciplinary person at the school. And they may themselves also be a witness, but they're also the essentially lawyer for the other side, and then they will bring in witnesses from the school. There's two phases. First is a pre-hearing conference. When you're with a lawyer, that'll probably be waived. If you're not with a lawyer, they're just going to essentially lay out what the hearing process is. Then there's the fact-finding phase. That is a trial. There's opening statements. Then the school calls their witnesses. You're entitled to cross-examine their witnesses. And then you call your witnesses. They're entitled to cross-examine yours. And then there's summations. And the burden of proof here is extremely low. This is why it's very hard to win these. In a criminal case, someone's accused of bad conduct, right? It's proof beyond a reasonable doubt, right? That is an incredibly high standard. But here, it's substantial and competent evidence. Not even preponderance. Preponderance is a standard that says more likely than not. This is lower than that. Is there evidence that says your kid might have done this? Basically, it's really, really low. And things you have to consider, the decision of your child to testify. If you are really challenging the facts, it is often a good idea, unless there is a criminal case at the same time. This is going to go quickly. And for many of the level 4 and level 5 offenses, they are also criminal offenses. And we're dealing with raise the age is happening now, but until raise the age fully kicks in, these are kids being charged in adult court for almost all of these things. So if your kid goes and testifies to clear their name, that is going to be used against them in the criminal proceeding. So they should not testify if there's an active criminal case, but you should definitely do the hearing to get discovery that could be used in the criminal case. Hearsay is something that someone who's not there says in these written statements. It is admissible in these hearings. However, it cannot constitute the full evidence. Your child cannot be found to have violated simply based on hearsay alone. Then we move on to the dispositional phase. So you'll sum up, and then you won't know what the decision is. And then you're going to argue what the punishment should be if your child loses, which seems counterproductive, and it seems like you're giving in, but that's what you have to do. This is the point where when we talked about progressive discipline, they need to be reminded of that. It is the centerpiece of what they do, but they need to be reminded this student has been in trouble only once before. This is their first suspension hearing. To give them 20 days does not line up with progressive discipline. That is very important that they are reminded of that. I say it like 20 times, and it's probably irritating, but I feel like they need to hear it over and over and over again. If the child has disabilities, this is a time to start bringing it up. And also, if this school is not working out for this kid because they have burned bridges and it is not the place they need to be anymore, you can. This is a point you get an automatic transfer out of that school. If you don't want to, if it's not working out, you say I don't want in anymore, and they must put you in a new school when you get back. When you're done serving the suspension. And sometimes I believe, I don't know for a fact, but I do believe that if the child wants to switch schools, it could sometimes shorten the suspension because they want to get that kid out of that school. It's better for everyone sometimes. The decision comes 2 days later, usually. This is really frustrating if the school's agreeing to immediate reinstatement and now the kid's got to stay out 2 or 3 days longer just to wait for a decision. But this happens. If the student has a disability, 2 days later, so the 7th day, and there's a more than 10 days suspension for the year, that kicks off the manifestation determination review, which is literally what the name says. Is it a determination of if the child's behavior was a manifestation of their disability? And this is held at the school. Now we're back at the school. And the school personnel will be there. Will definitely be a school psychologist or a social worker. And here's where you look at the IEP and other records. You can bring in outside assistance. If your child sees a psychologist, you can bring them there. If not, they can call in, send a letter. I do believe in person is best, but it's very hard to get professionals to come in. And the standard there is if the school finds that the child's behavior had a direct and substantial relationship to his or her disability, I'm going to repeat that. The school finds that the child's behavior had a direct and substantial relationship to his or her disability, or the behavior was a direct result of the school's failure to fully implement the child's IEP. Then that's a manifestation. and that means a child can return to school immediately. If they find there was no manifestation, 3 days after that, and the suspension is 10 days, so it would be on the 10th day if you don't get any adjournments, they must come up with a suspension plan. This meeting is at the suspension school. And at the suspension school, they must come up with a suspension plan which describes how the child's needs will be met during their suspension at the suspension school. Once again, if you're unhappy, you can appeal. The appeal is only in writing. There's no appellate hearing, and the appeal is to the chancellor of the schools. It's in writing. It's a pretty quick turnaround on this. It's 20 days after the hearing or 10 days after you get the transcript. In theory, it's 10 days. It's 10 days after you get the transcript because it takes a while to get the transcript because it's not actually written at the time. It has to be taken from a recording, but that's the basic gist of school discipline in New York.
It's really important to me because I think the data bears this out. You know, when we talk about the schools to prison pipeline, certainly we all know, you know, African American Black students are disproportionately suspended, you know, when we talk about school suspensions. But maybe what's lost in the data is that actually students with disabilities actually have a higher disproportionate rate of suspensions. And that's true here in New York City as well. So Black and African American students are suspended less than twice their rate in the population, but actually students with disabilities are suspended slightly more than twice their rate in the population. So that's why actually some of these discipline due process protections under the IDEA are so important, okay? And Gary mentioned, you know, the manifestation determination review. And this is, you know, and actually let me step back a little bit because the Individuals with Disabilities Education Act was partly passed because of the long history of schools using discipline to warehouse kids with disabilities, you know. So they often would actually get kids with disabilities out of their school using the disciplinary process. So these disciplinary due process protections, the IDEA, are actually very, very important and things that you need to understand because there are some extra protections. Because if they actually followed, if the Department of Education actually followed them, there could actually be some real changes in some of these students' behaviors. Because in my experience, more often than not, this is a recurring issue, you know, and ultimately it gets to the point where it rises to a bigger, more serious suspension, you know. But if they actually were following the laws correctly, they could have addressed it, you know, properly. And one of the things is that manifestation determination review. So as Gary mentioned, the law says that if you're removed, so this isn't just simply a suspension, it's not even a superintendent suspension, it's not even a principal suspension, it also includes teacher removals. So if the teacher removes the student from the class because that child is being disruptive, that counts as 1 day of removal towards that MDR. Okay, so even if it's for 40 minutes, I would argue that's 1 day of removal. So if there's 9 other, you know, days of removal, that very next day where that teacher removes that student for 1 hour because they were being disruptive in that class, that implicates the MDR. That's called a disciplinary change in placement. Sorry, throwing out all these terms, but it's important to hear it because it will come up. So once that happens, you know, there has to be this MDR. So this MDR can happen even if there hasn't been a superintendent suspension. So if your child, which I'm actually seeing more often now, there's all these series of principal suspensions. If your child has been suspended, you know, 3 times, 3 days, you know, for one incident, and then 4 days later on, and then, you know, another 3 days, you know, a couple of months later. And then that very next suspension, that, you know, if it's a principal suspension, that triggers the manifestation determination review. And it's really important to bring up the issues about the child's disability at these hearings, whether it's at the superintendent suspension hearings or even at the principal suspension conference, okay? Because you're entitled to challenge these suspensions, these disciplinary actions, okay? The principal suspension conference, as Gary mentioned, is less formal, but you still have that right to challenge that decision to suspend. And if you get the person who's deciding the facts of the incident, if they agree that that had something to do with the child not having the para, when the incident happened, that could then mean the difference in getting a positive manifestation determination review. So it's really important to look at these issues before the hearing, whether it's a superintendent suspension hearing or a principal's suspension conference. It's also important, if your child has been suspected of having a disability. So if your child doesn't, have an IEP, doesn't qualify for IDEA services or may have had difficulties, but people didn't make that referral. There is a process to get the same protections that we were talking about. It's a little bit more complicated, and I know we're running out of time. So maybe we can answer that in the Q&A. I did want to mention that if there is a positive finding at the manifestation determination review, meaning that, yes, they agree that the behavior that led to the suspension was caused by or substantially related to the child's disability, and that could be any disability. It doesn't have to be just simply the main disability that led to the special education services. If there is a positive finding, there are things that the school then must have to do, that the school district have to do. They have to then conduct a functional behavior assessment. So they have to actually do testing to determine, what is causing these behaviors. And from that functional behavior assessment, they should then develop a behavior intervention plan. And that plan should then help, teachers and whoever's working with that student make sure that behavior doesn't happen again. So if we're actually doing this right, I think we could actually substantially decrease the number of kids with disabilities being suspended and being funneled down that schools to prison pipeline.